Just have a look. Darian Fenton.
Chair, and thank you for the opportunity to make a contribution to Part 1 of the Employment Relations Bill number 2. This is the substantive part of the bill, and as the previous speaker said, there will be a lot of discussions, but the key thing that I wanted to talk about in my first contribution is the access provision in Clause 5, and Michael Woodhouse has put forward the National Party point of view, and I want to put forward the Labor Party point of view, and also the view that we heard from all of the union submitters and all of the union members who came to the Select Committee in large numbers and expressed real concern about these unnecessary restrictions that are being put on access. Now, what's interesting about this whole thing is it's really a solution that's looking for a problem. And we know, going right back to the regulatory impact statement, which goes with the bill, the Department was saying, advising that there wasn't widespread evidence of union representatives exercising their current rights to enter workplaces in an inappropriate way, resulting in disruption for business operations and so on. And they also went on to say they had no evidence to suggest that unions are not in general meeting the requirements under the existing Act. Now, Mr Chair, the existing Act has, contrary to some beliefs around this House, has a number of restrictions relating to access already. There are quite long, quite specific requirements on union organisers and representatives entering workplaces, and there's a number of conditions that have to be fulfilled. It's not a carte blanche, just walk into the workplace, don't have to have regard of anything, any conditions like health and safety or security, don't have to tell the employer you're on the premises and so on. And the conditions that are in the Employment Relations Act actually come from case law that was developed over many years, and in fact, under the Employment Contracts Act, when there were incredible problems with access provisions, incredible difficulties, which I think is why unions are fearful that this restriction is going to lead back to those problems and indeed back to the courts. This is going to be a bonanza for lawyers. And the only thing I can see in any sort of, from the National Party about why this provision is actually in this bill is because it was a National Party manifesto pledge. And it was one line in their manifesto. And like many of their pledges, promises before the last election, I mean, it obviously wasn't well thought out. It was just one of those sort of ideological things plucked from thin air, and there it was in the manifesto. And so, I accept that, given that they'd said they were going to do it, they had to do it. I accept that, even though they've decided to do some things that they didn't say they were going to do, which are in this bill, and as I said, will be discussed quite vigorously, I imagine, through the morning as we go through. But as I say, other than that, I can't understand why we're even having this debate about access. And I can't understand it because there isn't a problem. But what this will do is create a whole lot of problems, and we heard about them in the Select Committee. And I don't accept the example that Michael Woodhouse gave of unions, and Jordan McDonald's, I think it was, complaining about unions being unreasonable. Actually, they do have, under the existing law, they've got the ability to do something about that. They could have stopped that behaviour. I don't condone it. But actually, I don't see anything in this bill that will actually stop that sort of behaviour. If you're going to have errant union officials that are going to rush into workplaces and disrupt things, they're going to do it anyway. They're going to do it anyway. Then the employer's going to have to prosecute them. They have to go through the court. There'll be a court decision about what this really means. What this really means. It's going to be litigation all the time. It's going to be an absolute nightmare. But, one of the other things that I'm really puzzled about, Mr Chair, is in the initial Cabinet paper on access, there was a provision that the Cabinet signed off that this provision in this bill would not apply if a union organiser was seeking to access the workplace to look after the health and safety of their members. Now, that was in a Cabinet paper on the 11th of August 2010. It was advice supported by the Labor Department, apparently drafted in the bill, but never made it into the bill. And so I would like, if the Minister in the chair was able to, I'd like to know what happened to that provision about health and safety, because it's a very, very important part of being able to access. Mr Chair.
I call Dr Jackie Blue